members of the committee would take their seats. First up, would you identify who's on WebEx or members that are on WebEx, please?
Yes, Mr. Chair. We have Representative Potter, and I believe that is it.
Thank you. And Representative Potter is on. Good. Committee, I need to make a couple of announcements. I'm going to have a card up here in just a moment. I just sent we left it in the office. Representative Henderson lost his mother last night. So when the card comes, Connie's going to get it out. I'd appreciate if all of you would sign it, and we'll get it to him. So he's going to be out today, and he may be out for a couple of days next week. I don't know, but we'll be in contact with him. Our prayers go with him, and if you would keep him in your prayers. But other than that, the only thing we're doing today is a hearing on this bill. Before we start, bill introductions from committee members. Yes, go ahead, Representative Miller.
Thank you, Mr. Chairman. I would ask the committee to request that the reviser introduce 22 RS 2712. That's a fairly technical bill, relates to the format of stats, election statistics that the Secretary of State issues. I would do it normally in elections, but at this point we still don't have a meeting scheduled, and I wanted to get it moving.
I understand, and I would advise the committee. I have been advised by my leadership that we may be doing some election bills in this committee because the Fed and State and the Senate side does both Fed and State and elections. And if we need to conference.
That's reassuring because I know if it comes to this committee, it will get a fair hearing and a hearing.
Thank you.
Thank you.
Further bill introductions. And we also have the reviser that knows elections better than any of us. So that's always good. Any other bill introductions from committee members? Seeing none, any bill introductions from the audience? Seeing no bill introductions from the audience, bill introductions are closed. Committee, if you'd go look into your file or on your computer and look for House Bill 2502, I'll ask the reviser. And anyone object if the reviser does it from his seat here? He's got a lot of other things going on, and if you're more comfortable, okay, good. He'll give us an overview of the 2502.
Mr. Chairman, members of the committee, it's easier to stand because I can't see
I understand.
if somebody has a question behind me.
I just thought a man of your age, if you can sit, you can sit.
Well, I mean, you know, I probably need help to get to the podium, but I'll call on Representative Miller to help me. Anyway, or you, Mr. Chairman. But anyway, this is a bill dealing with retail liquor stores, and it amends a statute that deals with the licensure of these and what the license allows. And what the bill does is it strikes some language that they can sell and deliver liquor, cereal malt beverage to a caterer or licensed premises of a public venue, club, or drinking establishment. And current law provides if the premises are in a county where the retailer premises are located or in an adjacent county, and apparently this language has caused a little bit of confusion over the years, I'm not sure, but similar language needs to be stricken in subparagraph 3, which deals with cereal malt beverage and beer, which I missed when I drafted the bill. But anyway, if you have questions, I'll try and answer them.
Thank you. Questions of the reviser. And this bill did come out of the Modernization Interim Committee this summer.
That's correct.
But questions on the bill to the reviser? Seeing none, of course. I wasn't trying to pick on seniors because I'm a senior, but I know the reviser and Representative Miller, none of us are over the hill, but we have a really good view of the valley, but we're not over the hill yet. But with that, I have a number of conferees. I have one proponent. Scott, are you here? Good morning. If you'll come up, identify yourself. You're with the Kansas Restaurant and Hospitality Association. Scott Snyder.
Good morning, Mr. Chair, members of the committee. I'm Scott Schneider. I represent the Kansas Restaurant and Hospitality Association. For those on the Modernization Committee, you did not hear from me, but I was watching, and to honor the recommendation that you came up with, I thought it was appropriate that you would hear from the drinking establishments, the restaurants, the caterers, those in that sector. And this is something that we do support because what's happening in western Kansas is businesses changing, populations are declining. Those who have a drinking establishment are required to purchase their alcohol from a licensed retailer, correct? Well, when things shift and the economies move, if that becomes too difficult, that tells us that the Alcohol Control Act is too constraining and needs a little more flexibility in it. Just as a reminder, we have a 3-tier system. I call it a 4-tier system. You make it, you move it, you sell it. But in Kansas, a retailer who sells it can get a federal wholesaler's license to sell it to the drinking establishments, because the distribution tier might not want to sell a bottle of Jack Daniels to a liquor store or a bottle of wine. It's not efficient to do that. So we've accommodated that in Kansas and allowed the retail liquor store to make those sales. But what happens when there's not enough competition in that space in a sparsely populated rural county? I think this is something we're going to continue to struggle with over the years. This might not be the perfect answer, but I think it is something that deserves the committee's attention, and we support it.
Thank you. Questions for Scott? Yes, Representative.
Thank you, Mr. Chairman. And Scott, it says here deliver liquor and or cereal malt beverage. Is there any certain type of venue that would, you got to be 21 in Kansas to drink anyway, alcoholic beverages? Would they have to specially order cereal malt beverage to be delivered, or is it just?
I don't know that as a fact. I don't know every licensee in western Kansas or rural areas, but it is an option that our law allows. If you don't want to be a drinking establishment, because there are different requirements to be a drinking establishment than there are to own a CMB facility. So I don't have a great answer, but there might be a business reason to do that. I know of a CMB that's near my house that they don't want to sell hard alcohol or wine, and they don't want to have to go through the process to get a drinking establishment license.
Thank you.
Thank you, Mr. Chair. Thank you. Further questions? Scott? Now, my understanding, Scott, presently, and the reason this came out of the Modernization Committee is there's some misunderstanding, and when we had Matt Sterling here, our reviser, and I'm sure Mike is aware of this, is the ABC handbook had one definition, and then the statute had a different definition, and we wanted to clarify that, where they wouldn't be in conflict. That was the testimony at that committee. So that's the reason this bill was brought up, to give some clarification between the ABC handbook and the statutory authority. But
I do recall that, but I also wanted to bring to your attention, there are restaurants in northwest Kansas that can't get the wine that they'd prefer.
right.
So there are a few examples, not many, but a few.
All right. Any further questions? Seeing none, thank you.
Thank you.
I'm going to move to that was the proponent. Opponents, Whitney Dameron will be up first. He has another committee meeting that he needs to attend.
Thank you, Mr. Chairman. I appreciate the accommodation. Whitney Dameron on behalf of the Kansas Association for Responsible Liquor Laws. We observed this issue when it was taken up during the interim. I know there are sometimes some unique circumstances where a DE has, or caterer, someone has challenges getting the kinds of products that they want locally. I think the way it was discussed during the interim was maybe you could, there was a question as to whether an adjacent county meant counties that touched on the corner or whether they had to have a common border. I think that was clarified by ABC that if they touch, it counts. Don't know if that totally resolved the issue during the interim with the person who was a member of the committee who had this issue out in western Kansas. That said, we think the proposal before you is a bit broad, going statewide. It has some ramifications that maybe should be considered, and perhaps there's a way to do this more narrowly than what you have before you. I know the chairman has mentioned maybe instead of one county, it's two counties. We have suggested in our testimony that something like that is acceptable, or asking the director to make some kind of a determination if someone has challenges, and the director can give that kind of an accommodation. We're open to how that issue is addressed and resolved. We would not be opposed to something like that if the committee would consider that. So.
Thank you. I would say that I have what I would call the big four here as opponents. Although the director's not here, normally we do these type of bills and everybody's on board. So probably at the conclusion of this hearing, I'm going to recommend that you folks get together and see if you can arrive at some type of a compromise. And the chair would always be receptive to a compromise between all. Keep calling you the big four. I'm trying to think of maybe a World War II scenario.
Is that a weight joke, or is it?
It is a historical joke.
Okay, thank you.
But if questions for Whitney? Yes, go ahead.
Thank you, Mr. Chairman. Mr. Dameron, you said there might be some ramifications if this is passed as written. Can you go through some of those ramifications?
So if you have, for example, a liquor store in, say, western Kansas, maybe you only have one or two in a county, you set up a system where someone can deliver into that county to the other drinking establishments, caterers, and so forth that want this product. You may drive that retailer out of business. Most of the customers of that kind of a store are individuals and walk-ins. They're not, the bars and restaurants and the like. But if you materially impact that liquor store's ability to survive in a rural community, you may not have one in that community. You also may, quite frankly, if you're setting this up for some kind of a statewide delivery system, it may not be authorized under this bill, but you're setting the stage for some kind of a third-party delivery service that wants to come in and service these kinds of accounts, whether that's an Amazon or DoorDash or some of those kinds of things. And I think if the state's going to start going down that path and setting up a framework where that's allowed, we ought to do it with our eyes open so that people understand what the ramifications are on existing business as well as what it means for the delivery of these kinds of products.
Thank you. Further questions? Seeing none, thank you.
Thank you, Mr. Chairman.
And good luck at your next hearing. Next up, I'm going to just go down in order here. Amy Campbell. Good morning, Amy. Welcome to Federal and State Affairs.
Thank you, Mr. Chairman. My name is Amy Campbell. I represent the Kansas Association of Beverage Retailers. This is the statewide retail liquor store organization that has been in place since the repeal of prohibition in Kansas. There are approximately 730 or so retail liquor stores across the state of Kansas. A retail liquor store can get a federal wholesale permit in order to serve as a wholesaler to deliver alcohol and beer to the on-premise entities in their area. I did speak to the special committee during the interim, but this was not a topic that had been brought up before we submitted testimony, so I did not speak to this particular issue. Our viewpoint on this is pretty simple. If there is a problem, we'd like to know specifically what the problem is so that we can resolve that problem. The only problem I am aware of is the one that Whitney referred to, where there was an on-premise entity that was having difficulty getting choice in where they purchased their product, and they felt like that would be resolved if the counties that were adjoined to their county in a corner could be included in that area. I contacted the ABC director at that time. She clarified that yes, that is an adjoining county, and since then we've heard nothing. So I had thought that the issue had been resolved. We're happy to help with resolving issues, but we need to know what the specific problem is. One that was mentioned about getting wine in a particular corner of the state. Believe me, my retailers have that same complaint. We are a relatively small state population-wise, and so access to some products statewide is not universal. It never has been. Additionally, I would point out that the regional boundaries related to these relationships are somewhat coordinated with the regional boundaries that a liquor store has with their beer wholesaler. So any beer that's coming through the liquor store to the on-premise establishment is coming from that area beer wholesaler. If you go statewide, you're also disrupting that particular stream of commerce. Why is that important? Well, if you have a large purchaser, temporary permit holder, for instance, who's buying a large quantity of beer for some sort of a festival or something, and then they want to send that back, that typically is done through a cooperative relationship with that beer wholesaler. Now, is that beer wholesaler going to be responsible for that in Ford County when the beer came from Chase County? I don't know. I don't know the answer to that. That's one of the complications that you come into. At the end of the day, our primary issue is that this bill affects every retailer with a federal wholesale permit. Is that necessary? Do we need to do that? Or do we have a specific problem in a specific area that can be resolved by creating exceptions associated with the problem at hand? We are more than happy to talk about those particular solutions. I do want to point out that the retail liquor store does not have choice in who they purchase products from. Every bottle of wine, every beer brand that comes into the state is sold into the state under a franchise agreement. That franchise agreement is between the supplier and the wholesale tier. We do not have the ability to disrupt that, to go around the wholesale tier at all. So that's how it works. I'm happy to answer questions, Mr. Chairman. I think that basically covers our viewpoint.
Thank you. And my first question will be, you're willing to work with the other opponents and the proponent to kind of come up with a, you know, it's from my perspective, it's always best when you bring me to the solution.
So, yes, absolutely. But is there a problem to be resolved? We really don't like seeing the legislature pass statutes when there's not an issue to be resolved.
I understand, but we did have a member of the interim the modernization committee, and of course, we all being free market people up here, we like competition, and that was one of the issues that was brought out. And we're kind of stifling competition, but if we can expand that to be acceptable, but I'm going to let you folks try to come out with a resolution and bring it back to the committee at the appropriate time, if and when we work this bill.
Yes, and if that is the problem to be resolved, is the question of choice, then I think that is something that can be discussed, but I would point out to you that we don't have a choice.
Okay, I understand. Thank you so much. Other questions for Amy? None. Thank you very much.
Thank you, Mr. Chairman.
Next up will be Jason Watkins. You okay? Broderick. Good morning and welcome to Fed and State.
Yeah, good morning, Mr. Chairman. Jason Watkins, Executive Director of the Kansas Beer Wholesalers Association. Appreciate the opportunity to testify this morning. I'll try to be brief. The beer wholesalers do recognize the issue that's trying to be addressed We've talked with some of the parties involved in that, so we understand and appreciate it. We are opposed to this bill, however, because
I'm just trying to figure out where the next snack will be coming from. Since we can't make the determination, they can jointly bring in snacks for the committee. I appreciate that. Thank you very much. Go forward, sir.
Yeah, thank you, Mr. Chairman. We do, while we understand the issue that's trying to be addressed, we think this bill's approach is overly broad, and there could be a more narrow solution, and we would be supportive of that. Amy mentioned just a little bit about the beer market, and I want to just give you an example of why this bill would be a problem. And it is in my written testimony, but I'm going to, by way of example, use House of Schwan, which is an Anheuser-Busch distributor in Sedgwick County. There's a large liquor store in Sedgwick County called Jacob's Liquor. So if this bill became law, Jacobs would be able to buy a large order of, let's say, Bud Light. And it's going to be cases of Bud Light, and it's going to be kegs of Bud Light. And Jacobs is a big store. They've got vans. He's got money. He could create a pretty good operation. And he sells then a large order of kegs and cases of Bud Light to Duffy's Bar in Ness City, Kansas. I have no idea if there's a Duffy's Bar in Ness City, Kansas. I'm assuming there's not, but let's pretend today that there is, okay? Now, let me stop for a second. Beer wholesalers are required by their suppliers to buy back beer that goes out of date. It's very important to the beer industry that the beer that you're drinking is fresh, okay? So beer distributors are required to buy back beer that expires. Another thing that beer distributors are required to do is go out and clean the draft and tap lines in bars where our beer is being served. If you've ever gone to a bar and taken a drink and you're like, this just doesn't taste good, it's probably because the draft line wasn't cleaned. Those things can get nasty really quick. So that's an important process. We don't charge to clean those lines. And when we buy back that expired beer, nobody pays us back, okay? We destroy it. Directors here, there's a whole process we have to go through when we destroy that beer that we've bought back from that on-premise account, okay? So back to my example. Barry Schwan with House of Schwan in Sedgwick County sells a whole bunch of beer to Jacob's Liquor Store in Sedgwick County, and Jacobs trucks all that out to Duffy's Bar in Ness City, Kansas. Well, the Anheuser-Busch distributor for that part of the state is Western Beverage. Western Beverage didn't get paid on this transaction whatsoever. They probably don't even know about it. That beer then goes out of date, and Duffy's Bar calls Western Beverage and says, you're required to come buy this outdated beer back. And indeed, Western Beverage is. By the way, Western Beverage has been cleaning the lines for those draft systems as well, and again, not getting paid, and he didn't sell the beer. So that's the scenario that would concern our membership. Again, I think there is a good solution to this. I've talked a little bit with the chairman. We would be supportive of a change if it was more narrowly focused to solve this problem. With that, I'd be happy to stand for questions, Mr. Chairman.
Thank you. Thank you. Questions of Jason? Yes, go ahead.
Thank you, Mr. Chair. Jason, for Western Beverage and the one you mentioned in Wichita, do they have straight lines of their districts?
Yeah, I appreciate that question, Madam Vice Chair. They have franchise territories, and so House of Schwan's franchise territory is actually just Sedgwick County. Western Beverage has more counties, but those franchise areas are county defined by counties.
Okay, so if there's a change and say it's so many mile radius, do you think we need to have something in there that must be within that territory? Does that make sense what I'm saying?
It does. I will tell you, I like the idea a lot more of saying one county over or two county overs and keeping it defined by counties versus, say, a 50-mile radius or a 100-mile radius. The radius concept, I think, still creates concern for the people that I represent. I think it also creates an administrative challenge for the director and the folks in her agency. It would be a lot easier, a lot cleaner if it was just counties. So if you said, well, one adjacent county doesn't solve this problem, but two does, I like that idea a lot more than a 100-mile radius.
Okay, thank you.
Thank you. Further questions of Jason? Seeing none, thank you.
Thank you, Mr. Chairman.
Go to the top here, Tuck Duncan. Good morning, Tuck, and welcome to.
Good morning,
Mr.
Mr. Chairman. Thank you. Appreciate the opportunity to address the committee. You know, being at the top of the mountain, the view below is good, plus you have historical perspective. And I'd like to bring you, the committee, a little historical perspective. There's a couple of comments that were not precisely correct. Back in 1979, the courts determined that despite the fact we had a constitutional amendment that forever banned the open saloon, the sale of liquor by the drink in private clubs was legal. Prior to that time, it had been considered illegal to have liquor by the drink. Also, those of us who are at the top of the mountain may remember the liquor pool card and the liquor pools. I see a few people nodding their heads. So in 1979, when some guy by the name of Duncan was the Assistant Attorney General for Alcoholic Beverage Control, one of his tasks was to eliminate the liquor pools so that the private clubs, now restaurants, bars, drinking establishments, could sell liquor by the drink. Well, because the liquor pool was a trust where the bartender held your money, the bartender went to the liquor store and bought the bourbon, scotch, gin, etc. for you. It was a consumer sale. And he brought it back and put it on the back bar, and then he would take your shot out of that bottle and mix your drink and debit your liquor pool card. Well, when we changed the liquor by the drink, that meant that now the establishment was buying the liquor for their own resale. And so we eliminated the liquor pool. They were no longer buying it for you, the consumer. Well, that changed the whole nature of the marketplace. So the retailers came to the legislature and said, wait a minute, we don't want to lose those sales. Because under the new scenario, wholesalers would have been selling to all the drinking establishments throughout the state, not retailers. And the legislature said sympathetically, okay, we're going to create, and it may be the only four-tier system for both wine and spirits. They have a four-tier system in Texas for spirits, where the wine and spirits wholesaler sells to the retailer, and then the retailer sells to the drinking establishment. Now, this gave another unintended consequence. The federal government came in and said, oh, by the way, any retailer who is now selling to another on-premise establishment is, in our view, a wholesaler. And you must get a wholesaler's basic permit from the feds. And the state of Kansas has per capita more wholesaler basic permits than any other state. And in my testimony, I indicated there are 285 currently, and over time, there have been over 700 of those permits issued to the state of Kansas going back to 1949. That's why we have this system today. So we have it so that the retailers didn't lose sales. And now, I heard it said there was some confusion. If you read my testimony, and I'm just a liquor lawyer, I don't find any confusion with regard to what this statute means, but that may be because I was here when it got written. And what it says is real simple. Retailer can sell to an on-premise establishment in their county or in the adjacent county. The only confusion is a county at the northwest, northeast, southeast, southwest corner, just touching, is that adjacent? Director said it was. Most of us thought this problem was solved. So now, why am I concerned about it? I provided you with a map of all the current retailers located in the various in all the 105 counties. There are 20 counties, 20 counties that only have one liquor store. There are 22 counties that only have 2 liquor stores, and there's 35 counties that have 3 to 5 liquor stores. And obviously, most of these single and double liquor store counties are in rural areas. These sales, while not large, are still part of the revenue stream for these small stores. And so as we create a mega sort of mini wholesaler delivering to on-premise establishments out of Wichita and Johnson County and maybe Salina, we're going to diminish again that liquor store stream. A question came up, why do you have to have cereal malt beverage? You may recall we really don't have cereal malt beverage anymore. We have cereal malt beverage licenses, but that allows you to sell beer that doesn't exceed 6% by alcohol, which is basically 98% of all beers. So, and last year the legislature made it clear that you don't even have to have a CMB license now in order to sell cereal malt beverage in a drinking establishment. You can sell it under the terms of the drinking establishment license. So that's becoming sort of homogenized. And so that's why. So liquor stores now sell cereal malt beverage because they were selling strong beer. And so they're allowed to sell CMB to the CMB on-premise establishments, of which there are a few still left in the state. So we're concerned that what we're going to do is, now that we've given a significant part of the beer sales over to the grocery and convenience stores and bait shops, and we've reduced the revenue stream to these liquor stores who sell out in rural areas anywhere from 50 to 60% beer, we're now going to eliminate another source of revenue, the on-premise establishments within their county and adjacent county, and therefore we're going to end up with counties with no liquor stores. Katie, bar the door. I think you'll have people in here saying, do something. So we would prefer not to create situations where we have no liquor stores in any county. With that, I'll take any questions, Mr. Chairman, if there are any, and I'm always glad to sit down and come up with a solution. The speaker a couple years ago told Dick Stauffer and I to figure out how to solve the uncork problem. We took him seriously, we did. And now we'll be glad to work with you solving this problem.
Thank you, Doc. It's always interesting when you appear. We all get a history lesson as well as addressing the contents of the bill. I do have some questions. Representative Arnkamp, you have a question?
Thank you, Mr. Chairman. Mr. Duncan, can you walk through the process that a retailer has to go through with fees, paperwork? What's involved in becoming a wholesaler, a federal wholesaler, to get that license?
There is no fee, but there is a really long application. Now, you do it online now, or you can do it by paper, but you got to provide them information about your banks. You got to provide them references for good moral character. For us lawyers, that's always difficult to get those references, but you have to. I thought that might get a better smile, but so it's a very long application process, and it's not overnight. It takes anywhere from 90 days to 6 months for the TTB to process those applications. The law does allow, if you buy a liquor store that has a wholesaler's basic permit and you apply for a new one within 30 days, you can work off of the existing permit. But it can take some time, and then that has to be reported to the ABC, and that information. The reason I know that there's 285 current licenses is because the director showed me how to figure that out on her website. Does that answer your question?
Yes, sir. Thank you, Mr. Chairman.
Further questions? Again, I would ask that, you're great at coming up with solutions to problems. You have appeared here the last 6 years. I would ask that you work with what I'd referred to earlier as the Big Four, and you're one of those.
I'll get with Scott, and we'll go duke it out someplace.
Okay.
Figure out an answer.
Well, we don't have sports book betting yet, so we can't place bets on who would win.
Well, he'd win if you're looking at size.
Okay.
So.
All right. No further questions. Thank you very much. We have one more opponent. Phil Cosby, American Family Action of Kansas and Missouri. Good morning, sir, and welcome to Federal and State Affairs.
Morning, Chairman Barker. Thank you very much. My name is Philip Cosby. I am State Director for American Family Action of Kansas and Missouri. Concerning 2502, the sale and delivery of alcohol liquor to public venues, club, or drinking establishments, I respectfully submit, while the purposes of expansion of alcohol deliveries to clubs across Kansas, and I do stand and oppose to this drumbeat for modernization, I'd say that's a good marketing word. Who wants to be classified as old-fashioned? We have seen changes in our communities concerning liquor. Who would have thought when a few years ago they offered liquor to those that would go to art displays that you could have and serve liquor? I warned them at the time, if you pass this, McDonald's can serve liquor. I was laughed at, but today you see the Spangles. You can get your Happy Meal and your highball at the same time. Drive through. So modernization is a concern as to where we're going. Now, relative to the clubs and deliveries and alcohol and licensing, there's one category of businesses that is defined in Kansas Statute 12-770. They are sexually oriented businesses. The courts have upheld consistently, the studies are thorough and complete, and established that when you mix alcohol with strip clubs, you have a very bad outcome. You heard testimony last session on what you have in Community Defense Act as these effects. I am only suggesting that a possible consideration for a compromise and accommodation would look at the situation with sex clubs, with these strip clubs, due to the accompanying negative secondary effects of mixing alcohol and sexually oriented businesses, as defined in KSA 12-770. Sexually oriented businesses are prohibited from licensing and the sale of alcoholic liquor and cereal malt beverages. The Missouri law goes a little further. It says they prohibit the sale, use, and the consuming of liquor on the premises. So this is not something novel. This is something that states have done. It is common sense. The courts call it reasonable restriction. The role of alcohol at strip clubs. This is a little lawyerly, a little clinical, but this captures it. Proximity to alcohol is a key component to the criminological theory of secondary effects. Alcohol aggravates and SOBs already high ambient crime risk.
You need to stop you there, Representative.
Mr. Chairman, is this topical today on this bill? I just question the topicality of it and the need to hear this today at this time. I just appreciate your insight into this.
Well, we're here to hear the bill, the base bill. We're not talking about any amendments. That's at another time when we actually work the bill. Amendments can be offered. Of course, committee members can ask for any amendment. But you are correct. We're not going to get into what's commonly referred to as SOBs. Not at this time. If there's an amendment raised when we work the bill, then we address each of those. But today we're concerned ourselves only with the House Bill 2502. And thank you for bringing that to my attention. I didn't know how far we were going to go. But today we're only listening to testimony as it concerns the bill. Other subject matter, if there's an amendment brought at the stage where we're actually working the bill, then we will take amendments up. And if they are germane to the underlying bill, they will be voted on. And if they attach to the bill, then they will go to the floor of the House. That is the process that we work. I would suggest, if you want to talk about the SOB or sexually oriented businesses, as it pertains to alcohol, because you're talking at citing 12-1170, and we're in the 41, Chapter 41, which is totally different. So I will confine your testimony as to what is in 2502 as it pertains to clubs buying from retailer or wholesalers, and the vicinity of where that can take place as to whether it's a county or an adjoining county. I've not taken any testimony from any other opponents as to what their amendments may be. I've suggested that they go out and try to work up an amendment and bring it back to the committee. But if you're talking about an amendment, this is not the time to do that.
Thank you, Chairman Barker. I read your rules for conferees and did say if we suggested some ideas, in this case about alcohol, transportation, delivery, and clubs, those 4 points of commonality, there is a classification of clubs that Kansas has distinguished as having negative effects. So
I'm going to interrupt you
the
again.
chairman has ruled that.
I'm going to interrupt you again. My reviser is always on top of things, and he just handed me. Chapter 12 allows for the counties to regulate sexually oriented businesses.
I can answer that, sir.
And that's another chapter in the Kansas statute. It's not relevant here unless an amendment is raised when we're working the bill, and then a determination will be made whether or not it is germane to the underlying bill in question, just like we do on the floor of the House. So with that, I would ask you again to confine yourself to the contents of the bill, of whether we should expand or detract the distance that clubs can buy their alcohol and or cereal malt beverage. And
I will attempt to do so.
Okay, go ahead.
Mr. Chairman, I will attempt to do so of those points of transportation, delivery, confine or expand of clubs and alcohol. We'll do that. You reference counties. The Kansas statute does define what a sexually oriented business is as a club and the particular problems with those. My point of commonality is alcohol and clubs. May I proceed?
My question is, how does it go to the proximity of where a club buys their alcohol from? That's the only question that this committee needs to address at this time. This is a hearing on House Bill 2502. If it concerns itself with the, I'm looking to see how many lines there is here. I think there's 2 pages, 36 lines on the first page and 33 lines on the second page. If it's within that context, I will glad to hear your testimony. If we're going to get outside the subject matter, just a second, I'll get with you. Okay, I'm sorry, you have a question, Representative Garber.
Yes, thank you, Mr. Chairman. I would like to know if the reviser would have any input on this as far as relevance to this.
Well, that's the discretion of the chair.
At the discretion of the chair, of course.
It is. That's a simple way to put it. He advises me, and he's giving me notes, but it's my discretion.
That's right.
Right.
I agree.
Okay. Anything else? If we want to get into a SOB, and we've had a number of those bills in the last 6 years, Chair would always entertain a hearing on those. If a bill is introduced and it's referred to this committee, then a determination will be made by the chair of whether we hear the bill, work the bill, as always. But I just don't want to mix apples and oranges here. The bill is pretty restrictive in its...
I understand that, Mr. Chairman, and I appreciate that, and I understand that you have control of this committee, and I don't have a problem with that at all. But it seems to me, as I recollect in the past, other conferees have brought suggestions for amendments that we didn't sit here and determine if they were relevant or not. So I'm just wondering what's going on.
And usually it's from the folks that have the bill that it will affect, and/or it's always confined at a hearing level. It is always confined to the bill that we're hearing and its connection to the bill. And then when we actually work the bill, then amendments are brought that may be outside the scope of the initial bill, but it does connect. And when we look at whether they connect, it's just like germaneness. We look at the chapter that is touched upon and whether or not the amendment is germane to that bill. And we make that determination all the time on the floor of the House, as you well know.
Thank you, Mr. Chair.
You're welcome. I do have, Howe? Representative Howe?
Thank you, Mr. Chairman. I take no offense in letting the conferee finish his testimony. I don't necessarily think it's necessary to get into the weeds and trying to make too many connection points on it. I haven't been able to hear the entirety of his testimony yet to make that determination, so I would ask the chair that we just let him finish for the next 2 minutes.
I was going to let him finish the testimony, but I needed to address Representative Garber and Representative Epley. But it is within those confines. I've made my ruling on that. So please take your time.
Thank you, Mr. Barker. I will attempt to finish my testimony. And again, I understand that at a future date, amendments can be offered. Then it will talk about commonality where it touches as far as, and my position, of course, is on restrictions, licensing, transportation, clubs. That is the bill. And so this is one of those clubs that I'm talking about that is particularly identified in Kansas as a problem. Let me finish that paragraph if I might. Proximity to alcohol is a key component of the criminality theory of secondary effects. Alcohol aggravates a sexually oriented business's already high ambient crime risk by lowering inhibitions and clouding the judgment of the patrons.
I'll stop you there. How did that go into the proximity of where clubs buy their alcohol from? Those are effects.
I understand that in the future date, you will determine whether this is relevant.
And as a future date, I will gladly entertain an amendment that you will have a member of this committee bring. But as of today, I must ask you to confine yourself to the bill. That's what we're having the hearing on. We will have arguments on whether or not amendments are brought, and they will be explained in their entirety, and then the committee will make the decision whether to adopt or not adopt those. But I guess we're putting that cart before the horse. The first thing, this bill is confined to the proximity of when a club can buy and where they can buy alcohol from. Please go forward.
Agreed, Mr. Chairman. This is narrow. It is identifying one of the clubs. So I will carefully try to finish the modernization and the of this alcoholic highway that we find ourselves on, and consider, as you look at boundaries, barriers to the transportation and delivery, I would ask that you would consider this narrow talking point and suggestion that I have to offer. I am not making this up. The United States Supreme Court, every appellate court, federal appellate court, the Missouri Supreme Court unanimously upheld restrictions, and alcohol was one of those. That is a point of commonality here, delivery of alcohol. Kansas does differentiate on prohibiting spending cash at these businesses. I submit to the experience of the reviser that this is linked to other alcohol issues. I know you have a hearing next week. I would be interested as to how did Spangles drive-through get to where it is today when you see them? How is modernization really going to help Kansas? There isn't a person in this room that their family, some loved one, hasn't been destroyed by alcohol. Not one. And I know 2 out of 3 of you have drank, do drink. Some may have problems. I'm not being overly prudish here. In the last 13 seconds of the Kansas City Chiefs game, I was drinking a beer. So I'm not coming from that position. But I do recommend that these suggestions that I offer are weighted on points of commonality. With that, Mr. Chairman, I stand for questions.
I would add one thing. In the committee that we had, and Jordan, our research people, can touch on that, I think one of our recommendations is to stop that. It was done during the pandemic to allow you to drive through some of these places, pick up your dinner, and pick up an alcoholic beverage of some type. But I think our suggestions were, and Jordan, that we let that expire. It was only done for the pandemic reasons to allow that. But Jordan, I'll ask you quickly, did we not make that recommendation that those be expired or let to be expired?
Thank you, Mr. Chair. Jordan Milholland, Legislative Research. I don't recall a particular recommendation on that topic, but I do believe we discussed that as part of the overview of the legislation that had been passed.
And if I recall, when we put that into law, we had a sunset on it. So it was, I think, recommended that the sunset. I may be wrong there, but anyways, I didn't want to interrupt y'all. You're ready to stand for questions?
I am.
Thank you. Questions? Representative Howe.
Thank you, Mr. Chairman. Mr. Cosby, what specifically about this legislation do you object to as it's currently written?
Well, the marketing value of the word modernization, of course, is to move something forward in a fashion that you would perceive me as being old-fashioned or overly prudish. And I object to that. I think the subject of alcohol is certainly relevant to all of us, some very personally. And so the modernization of alcohol, and then by extension, the clubs to be considered about a category of club that Kansas has identified as a problem when you mix alcohol, delivering to these clubs, that particular class of club. What happens inside with the inebriation are some pretty terrible stories. I did receive a call.
No, you've answered the question. You have another question, please.
Say thank you.
All right, thank you.
Further questions? Yes, go ahead, please.
Thank you, Mr. Chair. Mr. Crosby, I'm looking at the bill. Where does the word modernization at all? I don't see the word modernization anywhere in this bill.
I think every conferee and the chairman has talked multiple times about modernization in the context of where this has come from. So I don't know that I can't use that since everybody else has used that.
Okay, well, all I'm looking at when I look at this bill is we're taking current statute and we are striking parts of lines 21 and 22 on the first page, and I don't see anywhere what that has to deal with what we're discussing right now. But that's my personal opinion. You have your own personal opinion.
That's a good question. I mean, schisms have come over that the word Trinity is not in the Bible. So we will divide on the concept of Trinity.
Thank you very much. No further questions? Thank you very much.
Thank you, Mr. Chairman.
If you desire and check with the office, we'll let you know when we're working the bill.
Thank you.
All right. Committee, that's all I have as for conferees. Is there other conferees here today that wish to appear on this bill? Seeing none, then I will close the hearing on House Bill 2502. We will meet next week. We're not meeting on Monday. I know you missed that. Eventually, we'll be meeting on Monday and probably on Friday. But I would encourage you to appear either by WebEx or in person. We have a presentation by Debbie Beavers, who's I was getting ready to say in the courtroom. She's, I guess, in the committee room today. And that's on Tuesday. Wednesday, we have Stephen Durrell with the Kansas Lottery. We'll be giving an overview of what the lottery does and how it affects Fed and state. And then on Thursday, we will be hearing a bill on removing inflatable devices that are owned and operated by a nonprofit organization from the requirements of the Kansas Amusement Act, RIDE Act, which we passed a couple of years ago, 3 years ago, I think. And this is subject to change. I think we'll get some bills in that we're going to read in maybe today or tomorrow. And if that happens, I'll probably be changing the schedule, and we may be hearing some additional bills next week. With that, anything else for the good of the committee? We'll have tomorrow's pro forma. I hope you get to go home tonight. I would like to be able to go home tonight, but if not, have a good weekend. We are adjourned.